Good afternoon, everybody. My name is Cleverson Xavier, and I'm speaking in behalf of the Sucro today. I'm going to present you guys understanding breach of contract with my colleagues Jonathan Regoza, Robert Smith, and Baltaj Singh. I'm going to walk you guys through the presentation for today. We're gonna talk about the types of contract breaches and as well as common causes. We're gonna bring two real example words. We're gonna talk a little bit about legal consequences and remedies, as well as preventive measures for the business. Before we dive on that, we're gonna understand what is a contract, right? So a contract is important because it defines rights and responsibilities, provides legal protection, builds trust, accountability, and reduces risk in disputes, right? So you set all your expectations and obligations on a paper written. It can be formal or informal as well. In a breach of contract, it happens when one of the part fails to fulfill their part, right? Without an excuse or lawful excuse. Types of contracts can be express contract or it can be an implied contract as well. An express contract, it's a clear, well stated, written down, where you put all your obligations and all your expectations for both parties. An example would be a sign of service agreement between a company and a contractor, right? And an implied contract would be something more informal, something that you do on a daily basis. A good example for that would be a haircut. When you get a haircut, you expect to get a haircut, but the person that does the service is also expect to be paid for it. Both contracts are legal and both can be lawful enforced. Essential elements that compose those contracts and characterize them as contracts will be an offer and an acceptance. Also, a consideration, some sort of value that is exchanged between both parts. Mutual intent, so mean both parts are intending to comply with the contract. The capacity of both parts to comply with the contract as well. And legality, right? Everything must be legal, do not involve any illegal activities. If any of these components are missing, the contract is no longer enforceable. And why it's so important to have a well clear contract, right? Of course, we want to prevent the breaches of contract. It minimizes misunderstandings. It set all the expectations and all the obligations for both parts, and that reduces the risk of disputes in the futures as well. And it simplifies resolution. If any discordance happens, it's easy to figure out the situation in the future, right? I'm gonna pass the word for Jonathan now, and he's gonna guide us a little more on breach of contract.
Okay, so let's begin by defining our core concepts. What is a breach of contract? A breach of contract occurs when one party fails to perform any terms about a contract without a lawful excuse. Okay, so next slide. To be a bit more formal, here's a more precise legal definition. A breach is a violation of a contractual obligation, failing to perform one's own promise by repudiating it or by interfering with another party's performance. Notice isn't just about not doing something, it can also be about rejecting the contract outright or getting in the way of another party's work. So, what does this look like in practice? Breaches can take many forms. Common examples include complete failure to deliver goods or services, missing deadlines, non-payment for work received, or delivering work that is substandard and does not meet the agreed upon specifications. It is important to note that breach isn't always a all or nothing. As the note here points out, even partial or delayed performance may be considered a breach depending on specific terms laid out on the contract. Okay, building on that, let's look at how breaches happened and more importantly, their real-world consequences. Breaches typically occur in a few ways through non-performance, defective performance, or late performance. Special category is anticipatory breaches, where a party signals ahead of time that they will not be fulfilling their obligations. The impact of these breaches on businesses are significant and far-reaching. They can lead directly to financial loss, either from missing revenues or the cost to fix the problem. The damages are earned. The damages harden businesses' relationships and cause reputational harm, and of course, they often lead to expensive legal battles. The types, the okay, the types of breaches: material versus minor breaches. Help visualize the landscape. The chart compares the three main types of breaches. We've discussed material breaches is a major failure that strikes at the heart of the contract, like a contractor no showing. This allows the other party to terminate the contract and sue for damages. Minor breach, sometimes called a partial breach, is a smaller issue that doesn't ruin the whole deal, like a slight delay in delivery. The contract remains enforced, but helps the party, uh, but the harmed party can still seek for compensation. Finally, we have anticipatory breach. that we just discussed, where a party signals in advance they will not perform. Okay, next slide. Anticipatory breach. Let's dive deeper into the concept of it, as it is a crucial one. This occurs when one party clearly indicates before the performance is even due that they will not be fulfilling their obligations. This can happen through a formal refusal or through actions that makes the performance impossible, like supplier telling you a week in advance that they can't deliver, or a freelancer booking themselves solid for another project. And that is just a chart of a couple previous slides that gives you the types of breaches and the definitions. Okay, I'll pass it on to the next person, which is Voltage.
Thank you, Jonathan. So we're gonna look at the real world example. So this is the case number 1. So this is for Parker versus the 20th Century Fox film. The parties involved was the plaintiff, Sheriff Parker. She was an actress, and then defendant was the 20th Century Fox Film Corporation. The overall case summary is that Shirley Parker was contracted to star in a musical film, but the 20th Century Fox Film did not do that movie, so they had to pay the legal fees. Next slide, please. So in this case, the studio had promised Parker a starring role, creative control, and a guaranteed salary. When the studio canceled the movie and offered her a different role, without those protection, it broke their contract because the new offer was clearly worse, and the Parker didn't have to accept it and was entitled to her full pay. Next slide. So the legal consequences and outcome. In this case, the studio breached the contract by canceling the movie out of nowhere. So she had no job at that time, and then they offered her Parker a worse job. It was considered a worse job by the court and Parker herself. And then the court said she didn't have to take the inferior role to reduce her damages. Next slide, please. Because of that, the studio back. Because of that, studio still had to pay her full amount she was promised, and Parker won the case and received the entire $750,000 guaranteed under the original contract. Next slide. So in this slide, we're going to talk about the legal remedies for breach of contract. When the breach occurs, law provides remedies for non-breaching party. First is mostly damages, monetary compensation, and then the compensation damages like mostly always cover the direct losses and cost. So when the contract is broken, the law provides remedies to protect the party who didn't breach. These include money damages and order to perform the contract or repayment of the unfair gains. Next slide. So the second one is going to be specific performance. A court orders forcing the breaching party to fulfill the contract, and also they're going to be common in contracts involving unique goods or property, and damages can cover actual losses, additional forcible loss, and symbolic amounts. Next slide. So the third one is going to be restitution. It aims to restore the injured party to like the original position where they would be if the damages were not there. And specific performance is used when the item is unique, and restitution returns to any unjust benefits. The remedy also depends on the situation and the harm that is caused. Next slide. So here we're going to talk about the legal rationale for each remedy. The first is going to be the damages. It makes the injured party whole. This is the most common remedy, and then the basic idea for this is to put the party that was injured to its original position where they would have been if the contract had not been broken. Next slide. It's going to be specific performance contracts involving uniqueness. So each contract is unique based on the different what the contract says and what the items are doing. And so this is often used in real estates, rare goods, or custom made items, and it ensures parties get exactly what they bargained for. Next slide. So the last one is restitution. It prevents unjust and enrichment. It focuses on fairness, that both parties are fair, and then one party does not get gain anything from canceling the contract. Next slide. So I'm gonna pass the mic to Robert.
All right, so I'm going to be leading the real world example number 2, case review, Haley versus Baxendale. Haley was the owner of a flour mill, and Baxendale is a delivery company. This is a well-known case within contract law. Just to preface, Haley owned a flour mill, and his mill completely stopped working because a crankshaft broke within the mill. He hired Baxendale, which is a delivery company, to transport the broken part so a replacement part could be made. He hired so after he hired Baxendale took on the role of delivering the goods. However, delivery was delayed, resulting in the mill being shut down for several days. Haley sued Baxendale for lost profits due to delay, and this case basically raises the question of whether a business can recover lost profits when the other party's delay caused them. It comes down to what was foreseeable at the time the contract was made, and when this slide, it kind of breaks down the breach again. Baxendale failed to deliver the crankshaft on time as promised. This caused a significant delay in repairing the mill. Haley claimed compensation for lost business income due to the mill being shut down for several days. Haley argued that because of that delay, he lost income and should be compensated for it. Baxendale's defense, or argued, he wasn't informed that a delay would cause a result in profits, claimed the financial loss was not foreseeable at the time the contract was made, and state that the standard delivery procedure was followed. So a legal issue becomes whether Baxendale could have reasonably predicted delay would cause Haley loss to his business due to the shutdown. Next slide, please. Outcomes for this, the courts end up ruling in Baxendale due to the damages damages being too remote, right? And not foreseeable at the time of the loss. The judges decided the financial loss was too remote because Baxendale wasn't aware the mill would be completely shut down. This case created the modern rule of foreseeability in contract law. Damages are only recoverable if they're reasonably predicted when the contract is formed. Lessons learned: always communicate special circumstances in contracts. That wasn't really communicated within this example. Foreseeability is the key when claiming consequential damages. And lastly, delivery contracts should define time sensitively clearly, which Haley failed to do so. Next slide, please. A couple comparisons. I know Baltej went over Parker versus Fox. There's a couple little differences. So we have type of breach of Parker versus Fox and material. Within my discussion, Haley versus Bechtel, it's a minor breach, delay in delivery. Remedy awarded, Parker was compensated. Haley was not compensated due to the damages being too remote. Key legal focus, change in contract terms. However, my comparison is the foreseeability damages showcased within Haley versus Baxendale. Can you go back to the last slide, please, real quick? So even though Haley did suffer real losses, right? The court said Baxendale wasn't responsible because he couldn't have known a delay would cause that much harm. Together with comparison 1 and comparison 2, these points highlight how foreseeability became a key role when lost profits can actually be quote unquote recovered. Next slide, please. All right, preventive measures and legal defenses, preventive strategies to minimize breach risks. So you have clear and detailed contract terms that defines the responsibilities, deadlines, payment terms, and deliverables. You have to avoid the vague language or open-ended obligations. Written documentation is very important. Keep record of communications, changes, and approvals. Use formal change orders or amendments when modifying agreements that were previously agreed upon. Dispute resolution clauses. You obviously have mediation, arbitration, and jurisdiction. Very important. Helps resolve disputes quickly and reduces costly litigation. Regular communication reviews and monitors performance, identify risk early, clarify expectations throughout the entirety of the contract lifecycle. Next slide, please. And we're going to kick it to Jonathan.
Okay, so now what if you're the one being accused of a breach? There are legitimate legal defenses. The first is impossibility of performance. The performance becomes truly impossible through no fault of your own, like a venue burning down before an event. The second one would be frustration of purpose, where the core reason for the contract vanishes due to an unforeseen event. Think of renting a space to view a parade and it gets canceled. And third would be waiver, where the other party voluntarily gives up the right to enforce specific terms, often through actions of the communications. The key insight on this is a proactive one. You have to be ready for it. Okay, so the next slide is lessons learned. Let's consolidate our decision into some key lessons learned for the real cases. First, clarity is critical. A detailed, well-written contract is your first and best line of defense, reducing ambiguity and making it easier to enforce terms. Second, foreseeability matters. If you see a risk on the horizon, communicating it early can help manage claims for their damages later. Third is understanding the differences between material and minor breaches. This is knowledge directly guides you in the remedy, whether which way you could seek compensation for smaller issues, and also prioritize early resolutions. Uses dispute resolutions clauses. Open communications can prevent minor issues from escalating into costly, time-consuming litigations. Okay, I'm going to pass it on to Baltej, I believe.
So we're gonna look at the recent legal trends. So there has been increased use of arbitration and mediation to resolve some disputes faster, and then the courts are also more willing to enforce the electronic and informal contracts, which before they were not that open. They want it all in paper and everything like that. Now they are open to do that. Growing emphasis on good faith and fair dealing in the contractual performance as well, and then the expansion of data privacy and cybersecurity clauses in contracts. That is a big major one as AI is expanding, so we need more privacy, so courts are more willing to do that. Next slide. So we're gonna look at technology's influence on contract law today. So smart contracts are going everywhere. So they're self-executing contracts on a blockchain with their automated enforcement as well. AI contract review. So AI is now reviewing contracts more faster. They're more accurate, and then they can detect the risk as well. So digital signature and e-contracts. So we've been seeing digital signatures for some time now, like for like 3 or 4 years now, but they're growing more, and then e-contracts are growing more as well. So the fourth one is contract lifecycle and management tools. There's more tools being available to manage the contract and the lifecycle of the contract as well. The technology is transforming how contracts are created more than ever now, and then how they are managed also, and then they are also making it clear and adaptability is more important than ever now. So I'm gonna
All right.
pass it to Cleverson.
All right, thank you guys. All right, those are the references we use it. They're gonna be available in this presentation. And we're gonna jump on a quick questions and answers that we got regarding to this presentation. I'm gonna start with Jonathan. Jonathan, why is contract law so important for business to understand?
Contract law provides the rule for businesses' dealings, turning promises into enforceable agreements. This creates a predictability needed to manage risk, plan for the future, and build trust with partners and customers.
All right, which type of breach is the most severe?
A material breach is the most severe because it destroys the core value of the contract. This allows the injured party to end the agreement entirely and sue for all their losses, not just continuing small claims.
All right, and how do you prove a breach of contract occur?
Proving a breach is a strict process built on evidence, which generally follows 4 steps. First is to prove the contract. Second is demonstrate your performance. Third, establish their failure. And fourth, quantify the damages.
All right, thank you, Jonathan. Now moving to Baltej. Baltej, why did the park initially engage in a civil lawsuit when she was offered a new role with a set payment amount?
She went to the civil lawsuit because the new role was not equivalent to the one Fox had promised before, because the substitute film was a different genre, and then they removed important contractual protections, and it was considered inferior opportunity than the one before.
All right, why didn't Fox Films offer Parker her the same contract?
They did not offer her the same contract because they did not make the original film, which was supposed to be Bloomer Girl, and instead they attempted to give her a film with less inferior role.
Right, and what happens when both parties breach a contract?
When both parties breach a contract, the court typically looks at which party materially broke the breach first, and then only material serious breach excuses for their performance, and minor breaches result in damages, not contractual termination. So overall,
Right.
court looks at which party made the breach first.
Thank you, Baltej. After a breach has occurred, what should be on the first step to resolve it?
The first step usually is communication and clarification. Contact the other party and then see what the breach was and how you guys can resolve it.
All right. Now, Robert, I have a question. Why did the court agree in Hadley's favor with Haller versus Baxendale?
Oh, okay. All right. You almost got me with that one. The courts didn't agree with Haley at all. They ruled in favor of Baxendale. The judge decided that the lost profits weren't foreseeable because Baxendale had no notice that the mill would be shut down during the delay. And go to the next question.
All right. With Hadley and Baxendale, did a breach of contract occur? If so, what type of breach?
Within this contract or case, it was a breach of contract. Let's see, Baxendale failed to deliver the crankshaft on the agreed timeline, so this is a breach of delivery obligation. It's considered a minor or non-material breach because even though the delivery caused financial harm to Haley, the breach itself wasn't intentional or severe enough to discharge the entirety of the contract.
All right. And what key mistake led the dispute in Hadley and Baxendale?
As noted in the previous slide about redundancies and clear communication, neither side clearly communicated how important the crankshaft delivery actually was, which caused confusion about who should pay for the mill's lost profits.
All right. Thank you guys for your expertise. And with that, we wrap up our presentation today. From now, we're going to jump on a quick reflection about how this presentation brought us together over here. I'm going to start with myself, and I'm going to go question by question. So what I enjoyed the most doing this working presentation was being able to directly work with my peers and have a deep diving understanding on what other people's opinions under this content as well. This project helped me understand better the legal environment of business on a sense of how important a contract is and what is the possible outcomes that a contract that's not well prepared can have, as well as a well prepared contract. The most challenging part for me was the fact that we are online class, so like working kind of 100% online is kind of hard to adjust and meet the time with my peers, but we are able to outcome that. And the biggest takeaway that I have from this project, it's like contracts literally are the base for anything. If you want to be safe, you rather cover all the bases. And I would like to let my professor know that my experience is being great so far, and I have a lot that I'm taking away like from this course, and I really enjoyed taking this class. I think I'm passing to Jonathan.
Okay, so for what did you enjoy the most about this presentation? I really enjoyed looking into the concepts with my team and figuring out how to break them down. Getting into details like the differences between material and minor breaches are actually pretty interesting. Did this project help you better understand the legal environment of business? It made it click. Instead of just being abstract rules, things like contract defenses and breaches seem like a pretty practical thing to know about. What was the most challenging part of the project? Honestly, the trickiest part was just coordinating everybody's schedule, making sure we were all on the same page. What is your biggest takeaway for the project? My biggest takeaway was how crucial it is to have a clear contract to start and to avoid the problems, but also if things do go wrong, it's reassuring to know there are structured ways to handle it. What would I like my professor to know? I just want to say that working on this project with my team really helped solidify the material for me. It gave me a foundation in this that I know will eventually help me down the line. So thank you.
All right. Let's hear from Robert now.
All right. I'm not going to read the questions, but I'll kind of go in. I enjoyed being able to conduct an actual presentation to see it all together, even though this is an online class. Pretty interesting to take everyone's input and watch how everyone can contribute in their own way to the final product we have now that we're now recording. And also working together as a group, we all respect each other and our boundaries and our input that we put in this project. This project helped me better understand the legal principles and how they actually apply to businesses in the real world, not just the theoretical, how business actually operate in our society. It showed me things like contract rules, liability, regulatory requirements that influence everyday business decisions. Instead of just learning definitions, I was kind of able to connect the legal concepts to practical examples. The most challenging part, like the other said, it's the managing everyone's schedules, also managing my own schedule, workload, my job, day-to-day responsibilities. Time management was definitely the biggest struggle through this entire presentation, but completing the project it feels fulfilling in a way. The biggest takeaway, my biggest takeaway is that legal rules in business aren't just theoretical. They shape how companies operate, make decisions, and handle disputes. Understanding how the law works gives you a huge advantage when analyzing business problems and preventing future issues before they occur or when they happen. Lastly, like my professor know about my experience, it helped me a lot feel more confident with the legal concepts that were discussed within each module. The assignments case studies made everything easier to understand, even though it was a lot of writing, and made them a little bit more realistic. Overall, helped me see how these laws show up in real business situations and essentially made the material click for me throughout each module.
All right. And lastly, we're gonna hear from Baltesh.
So what I enjoy about the working on this presentation was working with this amazing group and how our ideas come together, and then how did this project help you better understand this legal environment of business? So this project helped me because it went into a deep dive into how a contract works. I knew how I had a previous understanding of contracts, but I did not know this much about the contracts before. What was the most challenging part about the project? It was probably time management, like this class is online, so taking time out, it was pretty difficult, but we made it work. And then what was the biggest takeaway from this project? The biggest takeaway was the contracts are everything. If you don't have a good contract, then you can be pretty screwed. But if you have a good contract, then you are good and set to go. What would you like your professor to know about your experience? I would like my professor to know that this was a good experience. This class did a deep dive in different forms of understanding contracts and other factors as well. So yeah, it was pretty good.
All right. So with that, we wrap up for today, and that was our recording and submission. Thank you guys for paying attention, and thank you for your time.
All right. Have a good one.
All right. Did we